This is one of the harder questions when somebody has created content or they've got a coaching program or almost a philosophy. These can be fairly difficult to protect. Copyright attaches to the original work of authorship. If there's a certain layout to a handbook, if there are slides or photographs that were used, copyright can attach to parts of the content that's created. Blog posts for sure have copyright because that's an original work of authorship. Copyright can protect, the trademark can protect the identification of the goods and services, right? So if you think of, so it's not really a philosophy, but Bikram yoga is sort of a coaching technique, right? Bikram is registered, but the specific sequence of yoga poses that he put together, they were originally copyrighted, and then the copyright office, they canceled the whole thing. His whole yogic approach has a philosophy behind it, but he couldn't protect that through copyright. So you can't call your studio Bikram Yoga without a license, but you can just use that exactly everything that he does, that exact sequence, that exact temperature. So that cannot be protected. So there's indirect protection through the trademark, but nothing else through copyright. I haven't spoken about patents yet. A coaching technique or a philosophy, sometimes it might be a process. You could attempt to get a patent on it. I typically don't speak in absolutes, but I think I've never recommended this for a bunch of reasons. It's very expensive to do. It's probably more of a product of the mind as opposed to a true process. Patents don't typically apply, and even if you could get it through the patent office, it would be very difficult to enforce.